To settle in this country forever is not a right, but a privilege, and it must be earned. Today, that is not the case. Settlement, or indefinite leave to remain, comes almost automatically after 5 years' residence in this country. At that point, a migrant gains access to many of the rights of a British citizen, including to benefits. As a result of the unprecedented levels of migration in recent years, 1.6 million are now forecast to settle between 2026 and 2030, with a peak of 450,000 in 2028. It's around 4 times higher than the recent average. That will now change. As this government announced in its immigration white paper, the starting point for settlement will move from 5 years to 10. To ensure this is earned, new criteria will be added, which will act as a disqualifying bar for those who do not meet them. Firstly, the applicant must have a clean criminal record. Secondly, they must speak English to A-level standard. Thirdly, they must have made sustained national insurance contributions. And finally, they must have no debt in this country. While these criteria set the bar that everyone must meet, there are a series of other tests that have today been published for consultation, and these either add or subtract from the 10-year qualifying period. To recognise the particular value to society they play, the government proposes the following. Those who speak English to a degree-level standard could qualify for a 9-year path to settlement. Those paying the higher rate of tax could qualify at 5 years, while those on the top rate could qualify after 3, the same as those on global talent visas. Those who work in a public service, including doctors, teachers, nurses, would qualify after 5 years, while those who volunteer, subject to this consultation, could qualify at between 5 and 7 years. Not subject to consultation, the partners of British citizens will continue to qualify at 5 years as today. And this is also true of British nationals overseas from Hong Kong, who will qualify at 5 years in honour of our unique responsibilities to them. All grants under the Windrush and EU settlement schemes also remain unchanged. While some will be able to qualify for settlement earlier than 10 years, others will be forced to wait longer. Once again, these are subject to consultation, but the government proposes that those who have received benefits for less than 12 months would not qualify for settlement until 15 years after arrival. For those who have claimed benefits for more than 12 months, that would rise to 20 years. To encourage the use of legal routes into this country, those who arrive illegally could see settlement take up to 30 years. As has already been set out, refugees on core protection will qualify for settlement after 20 years, although those who move to a work and study visa could earn settlement earlier, and those arriving by a safe and legal route would earn settlement at 10 years. This consultation is open on some cohorts of special interest. This includes settlement rights for children, members of the armed forces, and victims of certain crimes. As well as considering the responsibilities that are expected of those who seek a permanent life in this country, the consultation also raises the question of the rights that will be provided. Specifically, it proposes that benefits might not be available to those who have settled status, reserving them instead for those who have earned British citizenship. Finally, this consultation addresses the question of the so-called Boris wave, specifically the cohort of lower qualified workers who entered the country along with their dependents through the health and care visa, some of whom are never expected to be net economic contributors. It is right that we apply more stringent controls for this group, and for that reason we propose they should wait 15 years before they can earn settlement. Crucially, for these and every other group mentioned here, we propose these changes apply to everyone in the country today who has not yet received indefinite leave to remain, though we are seeking views on whether there should be some transitional arrangements available.